My name is Tony Borden. I'm the Executive Director of the Institute for War and Peace Reporting, and we're really pleased to welcome you here this evening. This discussion is part of the larger project, our Kenya reporting project, with our good partners, the Wayamo Communications Foundation, the purpose of which is to support journalists in Kenya and media houses to strengthen critical, independent, and fair reporting on justice issues in the ICC. This is the fifth in a series of discussions we've had previously that have been in Nairobi, and we're really pleased to be able to welcome you here for this evening. We're also working with Radio Netherlands Worldwide, which has gathered comments from the ground, and these will be used during the debate as questions. We're also tweeting during it, and we may receive some incoming questions, and the event is also streamed live through reportingkenya.net and the Hague Trials Kenya from the Radio Netherlands Worldwide website. That only leaves me to thank our friends at the Wayamo Foundation and also our Dutch director, Marcel, and the IWPR Netherlands team for their great job in organizing this. And I'll hand it over to IWPR Africa editor Simon Jennings to do the introductions and begin the proceedings. Thank you very much.
Hello, good evening everybody, and thank you all very much for coming, and welcome to this, our fifth debate in the series, organised by IWPR and the Wayamo Communication Foundation. First of all, let's say thank you very much to our hosts here at the Bel Air World Hotel for laying on everything for us here this evening. And welcome to our distinguished speakers on this panel. I thank you very much for your participation in this debate. By way of introduction, first of all, I have on my right Ambassador Gerald Thompson, Trinidad and Tobago, and on my left, Dr. Sarah Nouwen of Cambridge University. Further to my left, David Donat-Katin, Senior Director of the Parliamentarians for Global Action. And all the way to my right, I have Mr. Njonjo Mue, a transitional justice expert from Kenya. So as I mentioned, this is the fifth in a series of debates organised by IWPR and Wayamo. Up to now, we've conducted our debates in Nairobi, so this is the first one we're holding here in The Hague. During these debates, we always try to have a balanced outlook, hear voices from all sides, all angles on the issue of international justice and the ICC. This evening we have a mixed panel. We were hoping to get representatives from various of the states parties over the way at the assembly that's ongoing, but unfortunately we weren't able to get any representatives to join us from Africa this evening. But I encourage everyone in the room to participate as much as possible in the debate by making comments or asking questions as I open the floor at regular intervals. So I'll start with the title of the debate, Sitting Heads of State on Trial, a leap forward for the ICC or the beginning of the end. So the ICC charged its first sitting head of state in 2009. The court issued an arrest warrant for the president of Sudan, Omar Al-Bashir, for atrocities allegedly committed in Darfur. The following year, in 2010, the ICC issued summons to appear for suspects in Kenya for the electoral violence that broke out in the country following a disputed presidential election in December 2007. In March this year, two of those suspects, Uhuru Kenyatta and William Ruto, were democratically elected as President and Deputy President of Kenya. Since President Kenyatta and Deputy President Ruto were elected as Kenya's leaders, the Kenyan government has sought to have the cases transferred from the ICC back to Kenya to be tried in the domestic jurisdiction. It has also sought to have the cases postponed by 1 year by the United Nations Security Council, and it's also made efforts in New York to have the cases terminated by the Security Council altogether. The Kenyan government is extremely concerned that the trials at the ICC threaten Kenya's security and that of the wider East Africa region, particularly following an attack by Islamic militants on a shopping centre in Nairobi in September. The African Union has also expressed its concern and in October issued a resolution that sitting heads of state should not be tried by an international court while they are in office. The AU has also urged President Kenyatta not to attend his trial, which is now due to start on February the 5th next year. So following the developments at the AU last month, the UN Security Council turned down a deferral request to have the cases postponed by a year, just about a week or so before the beginning of the Assembly of States Party meeting in the middle of last week. Consequently, a special debate was then tabled at the ASP to discuss the indictment of heads of state and government after Kenya tabled an amendment to Article 27 of the Court's founding treaty, the Rome Statute, that grants immunity, for it to grant immunity to heads of state while they are in office, as declared under the African Union resolution issued in October. Let me start with just a few figures that I think are quite well known, certainly to those familiar with the court. The court's been in operation for 11 years. It's conducting 8 investigations, all in Africa, but it only has 1 conviction to date. 12 suspects remain at large. 5 cases have failed to reach trial for a lack of evidence. The African Union, representing the largest bloc of member states, 34, to join this court, which was an institution of last resort for justice, was set up for the very purpose of trying senior state officials. So I'd like to start, if I may, with you, Ambassador Thompson. How unstable is the ICC as an institution if, at the first imminent trial of a head of state, you have such an amount of discord as we've seen in the last few months within that largest bloc, within the African Union, following the indictment of the head of state?
Thank you, Mr. Moderator. I would not characterize the situation as being unstable. I think what we're dealing with is the court, as it develops, is treating with real situations. This is the first time that a head of state has submitted himself to the jurisdiction of the court, and the court necessarily has to deal with that real situation at this point in time. So the fact that it has engendered debate, and also there have been efforts to cause amendments to be made to the rules of procedure, in itself, I think, is a reflection of the dynamic nature of the situation, and also it is also in a recognition that as matters develop, and you have indicated that, of course, there's been 1 conviction, 5 cases not pursued for lack of evidence. So it is not that you have a very large number of cases. But having said that, the number of cases are increasing, and therefore this then becomes a situation that the ICC has to treat with as it develops, as in fact it also developed its own jurisprudence. And as we have seen in last October, the appeals chamber has had cause to treat with the question of whether or not you can excuse individuals from the requirement to be present at trial. And it has dealt with that situation. It wasn't necessary to treat with it before. Now that the matter has come up, the court has dealt with it, and to the extent it has dealt with it, it has added to the jurisprudence of the court, and I think it augurs well for the future in that regard.
Okay, thank you very much. And Sarah, I'd like to ask you the same question, if I may.
Yeah. I think the answer to the question really depends from which perspective and from whose perspective. I think for the court itself, it need not come as an unstable situation in the sense that it seems that the statute always envisaged that this was a possibility, and Article 27 is very clear. that this is a possibility. And indeed, I would say that some would argue that this is a huge step forward for the court, because it shows that the applicability of the law to those the most senior, and particularly those in office. And the argument has always been that the ICC is there to uphold the rule of law and to show that even those in office are bound by international law. Now, then of course it could be the beginning of the end, as your question or hints at, and that could be in the following circumstances. First of all, if the ICC focuses more on enforcement than on doing its legal, judicial or investigative, prosecutorial and judicial work. So if the ICC becomes more a Ministry of Foreign Affairs than a judicial institution. And I think what we've seen in the first years, we've seen a few successful cases, but we've also seen a few cases failing as a result of a lack of proper investigations. And if you look at the rhetoric of the court and all the speeches before the Security Council and everything, there's so much emphasis on enforcement, enforcement, enforcement. Now, if we remember one of the things that Marty Koskiniemi has written about, he wrote, effectiveness, implementation, compliance are not the lawyer's problem, unless the lawyer has internalized the self-image of the political decision maker's little helper. So I think also in this situation it's extremely important that the court just does its legal mandate. If Kenya fails to comply, it refers that to the states parties. It's the Assembly of States Parties that has to deal with it. But it's not the court's mandate to go and try to resolve that issue. Now there are more pitfalls and risks, but I don't want to take the floor too long, so perhaps I'll come back to those.
Okay, thank you very much, Sarah. David, I'd like to ask you, particularly as a representative of an organisation that seeks universal jurisdiction for the ICC in terms of ratification of the statute. How stable is the institution if no matter how many states you have signed up, you then have this resistance that we've seen in the last few weeks?
I think this resistance is part of the game. If you create a court that is credible and does its job, certainly it's going to be unpopular. So, you know, the law is not there to protect the majority who goes to vote and elect whoever to lead the country, but it's there to protect the minority of those who have been victimized. And this is also the history of the evolution of international human rights law, out of which we also somehow saw the development of a branch of law that we call international criminal law, out of the Nuremberg principles. I do believe that instability in this type of situation is a necessary consequence of the gravity of the crimes. These are crimes that shocks the conscience of the entire international community as a whole. These are crimes, they are the most serious crimes of concern, and they include, of course, genocide, crimes against humanity, which is what is the case is about, war crimes and the crime of aggression, and whether correctly or not, other crimes like terrorism, you mentioned the Westgate attack, are not part of this body of law. I do believe that whatever the outcome will be, and I concur with Sarah, the court will have to continue to apply the law and be seen as an impartial, neutral force behind the application of the law without any distinction. If the court will continue to do that, then the idea that other states that are not yet parties to the statute could be encouraged, incentivized to join, the idea would take ground. If the court will not instead apply the statute equally to all situations, then of course this will bring detriment to the credibility of the institution. It was a project that started with the idea of creating some sort of instability, because when you change things become unstable. So there are problems, and the challenge is to analyze the pitfalls, the shortfalls, the limits that we have, and then move on and trying to address them one by one. So I remain very optimistic, and I do believe that once all states belonging to the international community will have ratified the Rome Statute, then the court will have universal jurisdiction, unless one of your states, like Germany did in 1998 in Rome, would suggest to delete Article 12 from the Rome Statute, so no preconditions for the exercise of jurisdiction, and this would be a court of universal jurisdiction. It was not approved in Rome, and the proposal was presented but was not approved, but maybe to counterbalance certain other proposals of amending the statute that are coming out, maybe this could be another option on the table. In that scenario, the let's say the allegation of double standard would simply would simply not be possible anymore to be made, because the court would have jurisdiction on any crime, ratione materia, and not because of the territorial or active personality link or the political decision of the Security Council to activate the jurisdiction of the court. Of course, this will not happen. I'm just putting on the table something that is impossible as of today to take place, but I just want to put down food for thoughts, because there are also other impossible propositions on the table, like moving forward and away from 27, which reflects customary law. So I do believe that if this type of proposal are brought forward, maybe we should consider to also bring forward other proposals that will render the court even more credible and universal as the one that we know today.
Okay, thanks very much, David. And finally, to you, Njonjo.
Thank you. I'm not sure whether there is much I can add to those views, save to say that we must go back to the beginning. We must ask ourselves why the ICC was established. According to the preamble, it was to ensure that the crimes that shock the conscience of humankind do not go unpunished. The second point to make is that we should not behave as if the ICC prosecuting sitting heads of state is news. It is not, because that's precisely why the court was set up. And even it was foreseen that this sort of situation would happen. That's why we have Article 27. I mean, Article 27. So the thing is, I think we must be unapologetic and state that the ICC was not just envisaged as a court of last resort, but as a court of nuncamas. It's a court of never again. And therefore, when we ask ourselves the question, is the prosecution of sitting heads of state a leap forward, or is it the beginning of the end for the ICC? I think it depends on how the ICC itself handles this foreseeable situation of having heads of state on trial. If the ICC stands steadfast on principle and doesn't allow itself to be threatened or bullied by organizations such as the African Union or states that have their leadership under trial, if the ICC stands steadfast in applying the law, then it will be a leap forward, because as Sarah says, that was what the court was established for. If, on the other hand, the court allows itself to cave in to political pressure, whether coming from the AU or a particular country or the Assembly of State Parties or even the UN, then it's going to be the beginning of the end. But that's because of how it handles that pressure. It should have, the court and those who are in charge of it should have foreseen this pressure that it would come because it's prosecuting powerful individuals all over the world.
Okay, thanks, Njonjo. But let me pick you up on that. I mean, we only have to look at some of the decisions coming out of the court around the Kenya cases, and we see a number of concessions from the judges, particularly the trial chamber, who originally granted absence to Deputy President Ruto and President Kenyatta for much of the proceedings. The trial judges, as opposed to the full plenary, actually supported moving the trials to the region at the request of the defendants. We now have some proposed amendments on the table around Rule 134 and attendance, but these sorts of concessions that are being made on the basis of state officialdom, whereby surely you can interpret this that then not everyone is equal before the law. Now, Sarah before mentioned diplomacy compared to law, a criminal court. Are these concessions, and I refer back to the title, is that not the beginning of the end for the court when it starts going down this road?
I think you seem to be agreeing with my latter point when I say that it will be the beginning of the end if the court allows the law to appear to bend to politics rather than the other way around. I'll just use an example of what happened shortly after William Ruto got permission to travel to Kenya for he said he was going to sit in for the president as he was traveling to Rwanda. And the following day, his co-accused Joshua Sang made an application that he wanted to go home and attend the graduation of his 6-year-old daughter. Now, the court refused Joshua Sang to go home for his 6-year-old daughter's graduation. And I'm not sure why. Because if Article 27 is saying everyone is equal before the court and before the law, then actually I would imagine that the graduation of a 6-year-old daughter whom you promised you would be there. And particularly because Joshua Rapsang was arguing that the only reason he wasn't able to attend his daughter's graduation was because the court itself changed its timetable, then I can understand why Joshua Sang would be asking that question. But the point I'm trying to make is that once you start making concessions on the basis of whatever the accused persons tell you, and especially because they are the head of state and his deputy. If I'm the head of state and the deputy, I can call my South African counterpart or my Senegalese counterpart and say, can you invite me for a cup of tea so that my deputy can come home? So that's the kind of ridiculous situations where bending the law to suit politics will end up. And that's why I'm saying that if the court is not careful in the way it handles this, in terms of whether it's concessions in court or whether it is the proposed amendments right now, which are trying to amend Article 27 and Article 63 by the back door through Rule 134, then that will be the beginning of the end. You either stand on principle or slow puncture yourself into irrelevance.
Okay, thank you very much. Ambassador Thompson, could I ask you the same question to you?
Well, I think Article 27 speaks to immunity. And it says, of course, with respect to that point, whether you are commoner or king, whether you're high or low, whether you're president or policeman, you are subject to the statute. The issue that's before, I think we need to separate that substantive point from procedural aspects of the conduct of a trial and the court deciding in the management of the trial whether or not it would excuse an individual for any particular period of time. The matters before, for example, the matters before the Assembly of States Parties now treats with, yes, it treats with the 27, it treats with Article 63, where there is an understanding, there's a default position actually, that the accused should be present at his trial. The court itself, in the development of its jurisprudence, has made the point that an individual, an accused, may be excused. And again, in the management of the trial, it is not unreasonable to expect that from time to time, issues may arise where you may need to excuse an accused who is before the court, who has agreed to be subjected to the jurisdiction of the court. Now, the difficulty with, I think, the trials of President Kenyatta and Vice President Ruto is that you have a provision in 27 which says that high office is not a bar. High office doesn't confer immunity, and you have these high officials who are being given to whom a concession has been made, a procedural concession, but their immunity is not in question. Sorry, the absence of immunity is not in question, and they are still subject to the jurisdiction of the court. I take the point that there's an issue with optics here, in the sense that you're making a concession to high office holders, the very persons with whom the statute is concerned, because these are the very persons who have the means, the resources to cause or to commit the offences for which the statute, with which the statute is concerned. But I think also we need to take on board that it is a procedural point. Do you allow? For how long do you allow? In what circumstances do you allow? And to the extent that the court has said that an accused may be excused, that applies, and that would apply, I think, to all accused, and not only the high officials, the vice president and the president. So, in theory, it can apply also to the accused, if the court is convinced that the argument made is a compelling one. So, I think I would concede that there is a matter of optics here, but I think also we need to have regard to what is the substantive nature of 27 and 63. 63 says you shall be present before the court. Yes. 27 says that office position is no bar to prosecution. Neither provision, I think, is in fact compromised by the court in the exercise of its jurisdiction, right, making these procedural decisions. Thank you.
Okay, thank you very much. I'd now like to open up the floor to any questions and comments from the audience. Please, if you could just raise your hand if you wish to speak, and then hopefully we can get a microphone to you fairly quickly, and if you would just identify yourselves and go ahead with your question. Yeah, over here.
You have to explain what they should be saying.
That's okay. Yeah.
Thank you very much. Just one point and one question. The point is that perhaps in the earlier question that you asked, by suggesting that this groundswell is recent, perhaps we may have missed a very important point, and that is that the groundswell is in fact quite some time in the making, right? It started in 2008 or so. I think that's a point that has to be borne in mind. And then just in terms of my question, Sarah Nouwen, you mentioned the idea that it's important for the ICC to stay clear of issues relating to enforcement and so on. And I assume from reading some of your work that this is linked to the idea of the ICC, to the question of the extent to which the ICC is political versus being judicial, and that perhaps being so much involved in enforcement questions and so on tends to push it towards the political. This is an assumption that I'm making. The question that I have for the rest of the panel members, because there seemed to be a lot of agreement amongst you, is whether or not the rest of the panel members in fact share this view of yours, that the court should stay clear of these issues and focus only on making decisions, judicial determinations, investigations, and should avoid questions relating to the extent to which there's enforcement. That I assume this would include questions relating to court officials lobbying delegates about what the rules should look like, and so on and so on. So I would be very interested to hear actually from the other members of the panel whether or not they would share that conception, assuming my assumption of your views are correct. Thank you very much.
Thank you. Do we have any other questions at this time? Please feel free. Yeah. Thank you.
My name is Korir, part of the Kenyan delegation. Actually, mine is more of a commentary in terms of the question before this panel. Essentially, I think the ICC is just, it's a court like any other. And so the question we need to be asking ourselves is, what is that ensures the legitimacy of a court? How does a court ensure its own legitimacy? And my view basically is that if a court is properly founded in law, if its prosecutorial policy is above board, if its prosecutorial choices are truly fair, if the procedural safeguards in the execution of a trial are above board, then such a court need not be afraid, or need not be threatened by whatever criminal defendants appear before it. A court needs to be afraid when it is aware that the prosecutorial choices that it has made are politically motivated. It needs to fear and quake when it is conscious that in fact the basis for decision making are issues or are evidence or is evidence that has been collected other than in the most, with the highest level of integrity. I believe that the ICC need not be afraid merely by the fact that it's engaged in trials of persons of the highest profile. If in fact these are the fundamental underpinnings, of the justice system. I mean, speaking in relation to the Kenyan cases, I think one must question the prosecutorial choices that have been made and wonder, in fact, whether the persons who are presently before the court are persons who bear the highest responsibility. Questions have also been raised in relation to the threshold of the crimes that are alleged to have been committed. The question being, are these crimes truly? Do they amount to crimes against humanity? And, when these matters were before the pretrial chamber, definitely, one of the judges dissented in terms of the threshold issues. And so I'm just emphasizing the fact that for the ICC to become legitimate, it must review very rigorously its prosecutorial policies. It must embrace wholeheartedly the procedural safeguards within the statute and not attempt to tinker with the mechanisms that have been set for the admission of evidence and the collection of evidence. That way, in our view, this court need not be afraid. Thank you very much.
Okay, thank you very much for your comments. I'll take one more question or comment if there is one at this point. No? Okay. Great. So if we could just I'll go back to the first question about the focus of the court and whether it should be confined to legal issues or go further in terms of enforcement and other challenges facing it. Sarah, did you want to come back on the gentleman first?
Thank you. There's no reason to come back in the sense of disagreement. You totally captured the point I tried to make. But what I didn't say in the first place, in the interest of time, was the corollary of that argument, which is that the ICC should leave states parties to reconsider things. And I read a statement yesterday by the Kenyan professor who said that ICC is a medicine which, when taken, kills the patient. Now, that may be because some states parties connected themselves to the drip without reading the instructions. And now that can be, and you hear it a lot, well, you have signed this, so this is what you've signed up for, so you better stick to it. But that's not the case either. States are entirely free to review their what they've signed up to. Of course, they cannot amend things unilaterally, but together they can do a proper, and I don't mean the stock-taking exercise of 2000 in Kampala, but I mean a proper stock-taking exercise of what is the impact of an absolute war on impunity, what the ICC is all about, and what is the impact of this war being absolute in the sense of uncompromising vis-à-vis other aims. And I think the ICC itself should realize, okay, we have been given this mandate and we do this as good as we can, but states are entirely free to reconsider as well how they balance that particular value with other aims. So this is all to create some disagreement, perhaps.
Thanks very much, Sarah. David, can I ask you to respond?
I think there was no need. But the disagreement is that I do regard Carla Del Ponte as having been the best prosecutor of the ICTY. She went to the council. She was not popular with the council members, but she got what she wanted. Arrest warrant executed. Was that politics? I don't think so. I mean, a prosecutor is a prosecutor, has a special mandate to put forward. And of course, a prosecutor applies the law. A prosecutor that wants the arrest warrants to be executed is a legitimate prosecutor. It's a legitimate position for a prosecutor to have. As an attorney general or prosecutor general of the republic in any one of our national systems. It's not politics. It's about having the law applied properly by those who have the responsibility to do so. So I do not, I don't know, I haven't read everything that was cited here, and apologies for my ignorance, but I do not regard the extraordinary accomplishments of the ICTY also through the work that the prosecutors have done in promoting the compliance of states with the ICTY statute and relevant Security Council resolution as a politicization of their mandate. Not at all. Even because these were prosecutors, were not judges. We need to differentiate what is the proper role for a prosecutorial magistrate and the proper role for an adjudicating one. And those are the one having the last word. Well, if I was the author of this event, I would have changed the title. I'm not, so that's good. I would have said voluntary appearance for crimes against humanity, a leap forward for the ICC or the beginning of the end. This is the problem. Can you really expect an individual to come forward voluntarily and defend himself or herself, as it's easy and he is full right to do so as a free person if the charges are so serious? And isn't it that the statute provides for certain provisions that impedes those types of individuals that may escape, may reiterate the commission of the crime, which is certainly not the cases of the two persons that we are talking about here, but or tamper the evidence or pose a threat to the integrity of the evidence. Well, were those conditions in place when the individuals were allowed by the prosecutor and above all by the judges to appear voluntarily? Are those provisions being respected today? This is the questions we should pose to ourselves. This is where probably the court got it wrong. Am I right or not? If I'm accused of a single murder, am I allowed to walk free and defend from self by flying back home every weekend or every day, every week? For a single murder? No, my friend, no. You know, you are presumed innocent, but you can defend yourself in all ways, and you can, if you have ability, if you have money to go and influence people, you are constrained, and you defend yourself as either at house arrests or as a detained person. It's a norm when there are very, very serious crimes, when there is an entire machinery. You know, those involved in certain crimes are not doing those things on their own. You have enormous...
President Kenyatta and Deputy President Ruto have pledged to cooperate with the court. They've pledged to clear their names, and they've cooperated with the court throughout
I hope
the process.
they're innocent. You know what? I really hope they will be acquitted. I really hope. I do really believe and hope that if they are innocent, they will be acquitted, and we will all be. This will have an happy end. So wonderful. But what if not? And we have created now this enormous conflict. So if I have to look back at because Sarah correctly mentioned the need to go back to the stock taking or shortfalls, pitfalls. Let's look at the things as they are. In my view, it was not right. It was not appropriate to issue these summons to appear. There should have been other ways. And of course, you cannot really allow 2 years to pass between the pre-trial stage and the trial stage. You cannot do that. You need to be a bit more efficient and effective. And I do believe that it's not really a matter of legitimacy here. I think this court is, you know, the legitimacy is there, the law is there, the judges are there. It's really a matter of making it work effectively. Yes, we can believe that two individuals want to cooperate, and we can believe in the story that they are fully cooperating. I also believed in it, so I was also wrong. But given the developments of these last few months and more, I think I was wrong, because also there is an asymmetry here. You have when we deal with heads of states, they have an entire apparatus behind them, and on the top of it, if these heads of states, they also have a private capacity to mobilize assets and media and other entities, you know, there is an imbalance there. You know, we have seen it in many years of proceedings against sitting prime ministers in my own country and in other countries. So this is where the situation becomes controversial, and there are probably there are situations that the court will have to reevaluate in the future, and when this will be surpassed, this crisis will be surpassed.
Okay, thank you very much, David. If I could turn to the second point that came from, I remember the Kenyan delegation on prosecutorial choices. And Ambassador Thompson, can you speak to that and some of the prosecutorial choices that the court has made, and particularly also about this debate over the threshold of seriousness of crimes and how that's affected its operations?
Well, the court, the ICC is an international court. It has a statute which would guide it as to whether or not the matters that are brought to its attention crosses a particular threshold. You have, and there is a structure as well in the statute which requires, of course, the prosecutor to seek indictments. Prosecutor goes before the panel of judges, in order to convince them that an indictment should be handed on in respect of particular offenses. To the extent that that is followed, I would accept that the correct threshold has been applied. It's only in time, that one would be able to question whether or not, in fact, that was an error. But we're dealing with a court which is a relatively young court. We're dealing also with matters of great significance. We're dealing with heinous offenses. We're dealing with issues concerning human rights, humanitarian law, the most atrocious crimes imaginable. That being the case, of course, and also bearing in mind that it's been done in accordance with or pursuant to a statute which would guide both the prosecutor and the court. Those I have no evidence that, in fact, that the thresholds that should be applied have not been applied. Again, bearing in mind the nature of the offenses, bearing in mind as well, if the court, over time, one will be able to judge whether, in fact, the correct decisions have been made. I am not at this point in a position to say that, in fact, those decisions were incorrect.
Okay, thank you very much. And so, I mean, sticking with this theme of prosecutorial strategy, and Njonjo, so, I mean, we might say, looking back over the indictments, the arrest warrants that the court has issued, for example, in Uganda, DRC, it's come under criticism for focusing on rebels and not investigating members of government. We have the Ivory Coast, where we have the former President Laurent Gbagbo charged, but we don't have the incumbent or any charges against the incumbent government. I mean, to what extent, in terms of prosecutorial strategy, is the court like doomed if it does, doomed if it doesn't? Effectively, you get resistance if you go after incumbent governments or heads of state. It suffers accusations of bias or over-selectivity in cases if it doesn't. What's your view on that?
I think before I come to that, I'd like to just quickly, with your permission, respond to my friend Korir.
Oh, yeah, please go ahead.
I find it a bit amusing that Korir is alluding to the court fearing and quaking in its boots, and that it need not fear if it has done A, B, C, D. But it's not the court that has been forum shopping from the AU to the UN Security Council to the ASP, avoiding to go to court. The court has been very ready, as it has demonstrated with William Ruto, who has appeared and submitted himself to the jurisdiction of the court, and his case is going on. So I think it's a bit, it's flipping the argument on its head to suggest that the court need not be quaking in its boot. And I don't speak for the court, of course. I'm just speaking as a Kenyan who's been observing this. Then second issue is about him claiming that those with the highest responsibility are not here. I don't know the body of evidence that the prosecutor relied on to bring these charges, but I think he seems to be laboring under an interesting narrative that has been emerging in Kenya to suggest that because Raila Odinga and Mwai Kibaki are the two individuals who ran for office in 2007, then they automatically bear the greatest responsibility, which is obviously not necessarily the case, because I can run for president and my friend Korir can so believe in me that he goes and kills people when I'm not declared. That doesn't mean that I should be charged with the offenses that he commits. And thirdly, very quickly, is about the threshold issue, if I may. It is true that Judge Hans-Peter Cole dissented on whether the threshold had been passed to make these international crimes. And the issue there was about organizational policy. I don't want to go into the details. I think that is now water under the bridge. He dissented, but the majority ruled, and we have that. The train has left that station. My friend Korir, I think I would like to use a popular Kenyan saying, accept and move on. With regard to the prosecutor, the question that you've asked me, and the prosecutor being damned if he does and being damned if he doesn't. I wouldn't want to sit here and pretend that the court has been perfect in the choices that it has made. Questions have been asked. Questions have been asked about Louis Moreno Ocampo appearing on camera with Yoweri Museveni to announce his first case, opening of a case against the rebels in northern Uganda. And as you have said clearly, that there are issues about who he indicts that starts to make the court look more and more like Victor's justice. But again, you come to Kenya, and the prosecutor indicted 3 people from both sides, and 2 of them then got on to become president, deputy president. And he still gets, or now Fatu Bensouda now still gets blamed for that. So you may be quite right that you're damned if you do and you're damned if you don't. But I suppose if you're criticized by everybody, you must be doing the right thing. That's not to say that the prosecutor needs not learn the lessons that need to be learned and listen to fair criticism where it is there. But the prosecutor should not allow the fact of those question marks being raised to derail the debate about pursuing justice and accountability against atrocity crimes.
Okay, thank you, Njonjo. So Sarah, the sort of same question to you with this dilemma perhaps that the prosecutor is faced with. But in light of that, is this level playing field, equal investigations of all, wherever there are allegations of wrongdoing, is that a dream of the court, or is it a reality that it can reach?
Yeah, so that's a beautiful continuation of where we started. We started with this ideal of Article 27, and in that sense that what is currently going on is the ideal because it shows that even presidents are accountable before the law. At the same time, we all have seen that these rules are enforced in a world of incredible material, political, substantive inequality. And that has clearly, I would say, impacted on what the court has done. You have referred to the discrepancy between, on the one hand, power and the rebels in particular countries. I would say Sudan and Kenya are the only states where, and Kenya now, but not at the beginning so clearly, but at least where incumbents have been targeted, and in the others it has been mostly rebel forces. So in that sense, the court has mostly followed power rather than spoken against power. But even more so, I would say, it's not so much within situations, but the selection of situations itself. And then I think that's what my South African brother referred to when we talk about this groundswell of the problem. To be honest, I think this entire thing about whether or not the president has to be here or whether he can Skype in for his trial is a bit of a non-issue. I think the real issue, and the problem is that we haven't had it articulated yet, is the key question: what does justice mean? Now, of course, we all know that justice in the context of the ICC is accountability, but there are so many more other conceptions of justice in this world. And one of those many other conceptions of justice, in addition to retributive or restorative justice, is also justice as equality. And I think what part of the sentiment in Africa, and I'm not saying that every African, but at least within the African Union, is that perhaps that the incredible selectiveness of situations now is fundamentally undermining this principle of this principle of equality, justice as equality. Now, there are two things of how do we deal with this. On the one hand, all the supporters of the court, and I think they're absolutely right in that idealism, they always say, you know, it's true, we are not universal yet, justice is applied unevenly, but the glass is half full rather than half empty, we're striving towards a full cup. And I think that's true if you define justice as accountability. We're getting there, we're getting closer and closer. But for those people who define justice as equality, the glass is getting emptier and emptier and emptier, because current inequalities in the world seem to be entrenched by the court. And I think this is part of this groundswell of problems that is now being defined as an issue of whether the president may or somebody may go home for the birthday party or the graduation party of the 6-year-old daughter. It's actually about much more fundamental things, and I think the key challenge for both the African Union is on one hand to formulate this, but on the other hand for all others, including panels like this, is to address the core issues.
Okay, thank you, Sarah. David, would you like to take up any of those points on that dilemma? Thank you.
Yes, of course, criminal justice is only a very, very small component of the type of policy measure that you can apply to make things work. And we know it as the ultima ratio or extrema ratio, or the last type of measure that you can take in very difficult situations where other remedies are not available. Honestly, the type of jurisdiction that the court has has been probably one of the main drivers of the selectivity in terms of situation selection. There are certain legal parameters that exist and cannot be avoided, and these are the reasons why certain situations like Syria do not fall under the jurisdiction of the court. Yes, it doesn't look good that the court is active only in certain situations, not in other, but probably this is the start of a long journey that one has to. Yes, it's the half full, half empty. I know I'm too optimistic here, but I think it is very important for us to be realistic and try to see whether this project is having a preventative effect or not. And yes, it's very difficult to prove, but it has had, in my personal view, in certain situations, an important impact on a certain number of policymakers, including those who belong to my own organization, who happen to be, in many, many countries, very influential figures who can advise presidents, take executive decisions, and be scared if the wrong decisions are taken, and certain consequences may occur. You may say, this is just speculative. Let's look at the statistics. And let's look where we are failing. Let's look at what we are failing. Probably the place in the world in which we are failing most is called the Central African Republic. And nobody mentions this country. I repeat it in every speech I can give. I will repeat it again and again. There is something happening there that looks like the next bloodshed. And voices have spoken about it. And there is a case before the ICC about certain crimes committed by foreign troops that went in at a certain point in time, at a certain point of an armed conflict that took place in 2003, the Bemba case, and Bemba being a Congolese. And there is an urgency here for the Office of the Prosecutor, who, however, has a role that is comparable to the 0.05% of what the international community can do to stop the massacres in Central African Republic, because, of course, there are others who can do much more. First, the Security Council, and including, of course, the African Union, and under its constitutive act. And this is really where the challenge is for us, to maximize the impact, to make sure that as we were witnessing the Côte d'Ivoire conflict erupting, that it would have not become another Rwanda, because that was the discourse back in 2002, 2003. And it was the side of former President Gbagbo that accepted, as a non-state party, the jurisdiction of the court in the first place. It didn't happen naturally like this. It was a process that involved a lot of policymakers who advised him to stop certain practices. And advise also the wife, by the way, who was the head of the Socialist Party group in the Ivorian parliament. So these things have had an impact, because if you look at many, many years of conflict in Côte d'Ivoire and you look at the statistic of victimization, those statistics are very serious, but cannot be compared with Rwanda or with other situations that we have known in the 1990s. So we need to be realistic. We need to understand where we can have an impact. And I still believe that the fact that the ICC exists with all the shortfalls and pitfalls of the project has had and is having a tremendous impact on decision makers. And our challenge is to make it universal, to make it accepted by everyone, to have the major powers to join in, because it's useful to all of us, and they have no reason to object in our organization and also personal point of view, and make it move the international community towards more a rules-based order than an order based on power and other values that are prevailing today. Maybe this may not be the most important movement towards equality. Maybe we need something else. So we are doing the wrong thing. So I think that's Sarah's position. But I do believe that the ICC, and for what criminal justice can achieve, is a very, very valuable project still.
Okay, thank you very much, David. My next question, we talked a lot about prosecutions, the law vis-a-vis politics, but something that was key at the center of the Rome Statute when it was formulated back in 1998 were the victims. Victims of these crimes were put at the center of the court's operations. A recent poll conducted a couple of weeks ago in Kenya had, as a result, 67% of those polled wanted to see President Kenyatta go to The Hague to answer the charges. If I could ask Njonjo, you first, to what extent are the victims still at the center of this project, particularly in the dialogue and the priorities of the state parties, the members of the court?
as you say, there's still a lot of support in Kenya, contrary to what some people have us think. 67%, and this opinion poll was taken just about a week before the ASP meeting opened. 67% of Kenyans are in support of the president coming to The Hague to attend trial and clear his name. But as you say, victims have not been front and center. They continue to, the victims who registered for the two cases continue to be represented in court, obviously. But the spotlight shifted and the narrative shifted a while ago with the increasing politicization of the Kenyan cases, whereby the suspects donned the heart of the victims. And it became, when the ICC was turned into a campaign issue, where the narrative was pushed forward that it was the former prime minister who somehow had the power to bring the cases to the ICC or invite Moreno Ocampo to Kenya, despite all the facts say, and the fact that obviously he didn't have that power. The two individuals currently in charge of the affairs of the state managed with amazing alacrity to use their power, their resources, and their control of the media, because in Kenya, most of the mainstream media is either owned by or controlled by politicians or their friends. And so with the kind of might that they had, even before they got into government, the narrative was changed, especially in the context of an election campaign, where the ICC was posited as an imperialist court whose agenda was regime change, or in this case, electing our president for us. So very subtly but very surely, that narrative has ensured that victims have moved from front and center. Even at the African Union, there was no voice for victims. Unlike here, where civil society has at least had a chance to address both the plenary and side events, the AU has no such space. And so the only person or people who speak at the AU are Uhuru Kenyatta and William Ruto and their representatives. And likewise, at the UN Security Council during the debate for the deferral a week and a half ago, likewise, you did not hear much about victims, although it has to be said that Fergal Gaynor, the common legal representative for victims on the Kenyatta case, wrote an excellent letter to the UN Security Council, which I think is available publicly, laying down exactly what the concerns of the victims were. And he is in constant touch with the victims. So he wasn't speculating. You know, a lot of times we are asked, civil society are asked, who do you speak for? Who told you, who have you been in touch with? But Fergal Gaynor is the victim's lawyer, and he talks to them every day. So the issue is that the issues of the victims are still of moment. They are represented both in court and also in forums such as the UN Security Council. But unfortunately, in wider forums such as the ASP itself, except insofar as civil society tries to get in its voice edgewise, and certainly not at the AU. Victims are not figured.
Okay, thanks, Njonjo. Ambassador Thompson, could you speak to that? And obviously, bear in mind there's 122 states parties. What is the priority for the victims?
Well, one casualty of the focus on whether or not the prosecutor should be interested in this matter, this situation, country, or the other, really tends to be the victims. Because in those countries where the prosecutor has, in fact, and the court has taken action, they are victims as well. So that we ought not to lose sight of that very salient fact when we debate prosecutorial choices. Because to the extent that you're dealing with choices, it means that they are victims, and if you're talking about a choice of two, it means that they are victims in both places. And to the extent that the court addresses one, at least it would have addressed some victims. So I think we need to be careful that we don't lose sight of the fact that there are victims wherever in all situation countries, and to the extent, of course, that the court and the prosecutor deals with one or the other, it means at least those victims will in fact get some attention. Now, it is true that victims, of course, would have a limited voice, a limited role. For example, in a meeting of states parties, again, the meeting of states. But it is also true that in considering, for example, the proposal to amend amend the rules of procedure, delegates were conscious that in fact you cannot simply treat with the prosecution and the accused in a matter such as that, because again, the victims have rights as well. The victims also seek justice. They would also wish to see, as it were, the accused answer to the charge that that the prosecutor would have brought on their behalf. So I think we need to keep the focus on the victims. It is not as great as it should be, but in dealing with the Assembly of States Parties does make an effort, bearing in mind, of course, the forum is one for states. An effort is made to accommodate the views and the situation of victims.
Okay, thank you very much. Sarah, would you be able to speak to the involvement of victims from Assembly States Parties?
I think that there are, as always, all kinds of levels in which we can address this question. What I have difficulties with is that rhetorically the victims are still centerpiece. In every sentence, in every speech, every first sentence, it's the victims, the victims, the victims. But the problem that is getting more and more pervasive is that the victims has become this kind of halo identity, an abstract thing that gives a holiness to the entire enterprise without having the power as a group, because they have been so abstracted from something, to hold anybody accountable for what's being done in their name. And the victims is so abstract. It's a group, but it's nobody in particular. And I think, of course, there's a huge gap there with the legal proceedings, where there should be individual victims with real experience, with a name. Well, usually they have a number, I think in the ICC proceedings, or a code, but at least individuals. But that participation has become more and more and more restricted and less individualized. So you get this increasing gap between, on the one hand, the holiness of the victims with capital T, capital V, as the justifying, almost sovereign of this entire project, and on the other hand, the reality of court proceedings in which the victim is participating less and less individually.
Okay, thank you. And David, if I could ask you to add your thoughts.
Well, we had victims coming forward and speak their story in the Bemba case. They came, women who suffered raped. They represented their views and concern under Article 68.3. We had a lot of victims who came forward as individuals and participated in court proceedings. Of course, in the Kenya jurisprudence, Sarah is right. The Kenya jurisprudence unfortunately got it wrong and blurred them into an undetermined group. Of course, we cannot really, as we can be critical of that jurisprudence, which unfortunately is the only one going in this direction. We, however, need to be a bit cautious because of security issues relating to individual victims and also, of course, to witnesses. So probably it's not really the example to be made. The court should be measured on other situations where victims may have and should have the ability to express freely their opinion and reveal their identity in a context in which they may not be at further risk of re-victimization, re-traumatization. So unfortunately, the Kenya case is probably the most problematic one, also in this respect. And I totally agree. And this was the outcome of the plenary session on Friday that I had the ability to summarize. bringing to the table the consensus of all that the first goal of victims' participation is to protect and respect the dignity of individual victims who want to see recognition as part of that important process, which we should not, however, overestimate, because, you know, what you can get out of a criminal trial is very limited. You know, it's maybe very important to the individual who suffer immense suffering, and any type of reparation may not be the one that will bring back any type of reparations that the justice process may put on the table may not be really comparable to the suffering that an individual has encompassed. So we need also on this one to be realistic and understand that there are limits to what the criminal justice process can offer. But still, I do believe that the individualized approach is in the legal framework. And if in one or two cases it was not applied correctly by the judges, the court has ample possibilities to correct the mistakes done.
Okay, thank you very much, David. I'd like to open the floor again. Please, if I could hear any questions or comments on any of the points that we've discussed so far, we'd all welcome to comment on them. In the front here.
Thank you. Xavier Jean Keita, I'm the Principal Counsel of the Defense Office in ICC. I heard David talking about what's happened currently in Central African Republic. There are other places in the world with, we can quote Syria.
It's not under the jurisdiction of the court.
No, but I am just quoting
we agree.
A place. The thing is, there are so many expectations. I'm in the defense side for the proceeding, but I totally agree that victim place now it's probably a problem. My question is, do we realize that perhaps we were too optimistic with ICC, and there are many expectations about ICC, when internally I realize and I fight every day about means, about budget? People are expecting that ICC can do everything, but we do not have the means to do everything, even for victims. Is it the responsibility of ICC to deal immediately with Central African Republic? What about Syria? What about Palestine? Can we be everywhere? Do we have this means? What about the responsibility of the UN? ICC is an exceptional jurisdiction, seeing that the priorities for the state themselves. We forgot the responsibility of UN, and this is our responsibility. When we talk about ICC, ICC is not perfect, but we have some political aspect, because if it is not an initiative of a state, it can be an initiative proprio motu of the prosecutor, but this is a question of strategy of the prosecutor. We can discuss about it. But what about the responsibility of the UN imposing a veto, preventing the international community of intervening somewhere? We should question that instead of focusing only on head of states.
Thank you, Ms. Keita. Have we got any other questions? Any other comments? Yeah. In the middle here again.
I hope I'm not being notorious, but
no, please go ahead.
I think it's really important to underscore the central place of victims, you know, in this entire enterprise. And I really want to say that in the Kenyan context again, there is a deep acknowledgement that enough has not been done in terms of addressing victims' concerns and rights. And that is why the Kenyan government has rolled out a very comprehensive program to reparate and resettle victims. And I am aware, for instance, that within this budgetary provision, over 4 billion Kenyan shillings, the equivalent of about 40 million $40 million US dollars, has been allocated by the Kenyan state to resettle victims and provide peace dividend resources to enable them, go on with their lives. We are really concerned indeed that the collectivization of victimhood in the manner in which Sarah articulated has neutered the voices of true victims in the Kenyan process. It has rendered victims impotent in terms of agency, so that strategic actors, such as my friend Njonjo Mue, can emerge and begin to articulate themselves as representatives of victims who, as a matter of fact, they have not met, they do not know, and they have not interacted with. And that, in our view, is the reason why this system cannot deliver as it is right now. It cannot deliver justice to the most important category of affected people, namely the victims. And I think that's something that we all need to grapple with. After the post-electoral violence, the Kenyan state established a Truth and Reconciliation Commission, for instance, to provide a space for honest conversation around the difficulties that had taken place in Kenya. Civil society, led by men such as Njonjo Mue, opposed that initiative and favored very strongly an initiative outside the Kenyan context, namely the ICC process. Our view really is that while acknowledging the fundamental role that the ICC plays, the primary responsibility for addressing the structural drivers of violence lies with the nation state itself. And even when it has been inadequate, the Kenyan state has made so much effort in the direction of meeting victims' rights, even when it had little capacity. Thank you very much.
Okay, thank you very much. Any more questions? Yeah, there's a hand in the middle there. Yeah.
Thank you very much for inviting us, and I think I want to say I've enjoyed listening to this, but I would like to just comment on the question of the so-called opinion poll, which is being referred to as reflecting what 67% of Kenyans want. I would caution here that opinion polls in Kenya, as we know them, are selective. They are dependent on whoever has funded the opinion poll, and therefore they should not be taken to reflect that all Kenyans, 67% of them, want Uhuru Kenyatta at The Hague. I think that is the caution I would like to give. I would also like to say that in terms of the victim, what Dr. Koril is saying is a correct position. Victims have been misused for purposes which depends on the person who has the vested interest in terms of what they want to achieve. They'll use the name of the victims so that they can come here to either at The Hague, instead of telling us the true fact of the victims who are Kenyan citizens and who Kenya government owes a responsibility of looking after. They want to come here, paint a picture of a government that has not cared about its citizens, a government that has not done anything in respect of anything that appertains to the victims. In fact, the record will show that in terms of the victims, right from 2009, the Kenya government has undertaken a process whereby it started by resettlement. It thereafter went into cash payments. It thereafter went into building schools and trying to give counseling and schools and facilities which were available. In terms of whether the Kenya government has been discriminative, there is no evidence here shown that the Kenya government decided that it was not going to take care of victims arising out of the current cases and dealt only with the cases of the ones who are being resettled. What the Kenya government was doing was in terms of the conditions in which the victims were in. Those who are outside in camps needed urgent resettlement and to be taken out of the bad conditions in which they were in. In terms of the other victims, alongside, there are very many other victims alongside, not just the ones whose names are in court, whose names are in the government records, because that's the Kenya government that went out first, took the details. It was not the NGOs that would have been in a position to take the details of the people who are affected. Those records are there, and the Kenya government continues to keep in mind the place of victims, and the Kenya government has projected to see what they can finally achieve. It is not instant coffee, and it's not possible to be achieved in a one-off. Kenya government is not the two accused before the ICC. Kenya government is the state, and the state which owes its responsibility to the citizens. Thank you.
Thank you very much. We have a question over here on the right. Two questions. Kyoko. Okay, come here first. Thank you.
Thank you for your indulgence. While Kenya still has the floor, I just wanted to add to what my colleagues have said, that first of all, let me categorically state that Kenya has not sought an amendment to Article 27. Merely what we are seeking is the procedural accommodation or concession, as Ambassador Thompson mentioned, for our leaders to be able to balance between their duties back at home and also their obligation here at the court. I then wanted to say that I know that Kenya went mad during the post-election violence, and it's not something that is so extraordinary. Other countries have also, there are some moments that other countries have gone mad, and these issues are not unique to Kenya. What is not being told is the story of the lessons that have been learned from that situation, the reforms that have been undertaken, judicial, electoral reforms, economic and social, and the efforts that have been made to restore the victims. It might, the government may not have achieved full restitution, but there has been positive efforts being made to deal with this matter, and my colleague, Dr. Korir, has ably and articulately stated the position. And the ICC also may have a role through the Trust Fund for Victims to assist. I'm not sure whether we have been able to tap into this, but that is something that the ICC could also help with in this scenario. We know that the court is seized with jurisdiction over the crimes in the statute, the crime of aggression and those others, and as an element of universal jurisdiction that is not expressed through the UN Security Council. And like someone, a speaker before me mentioned this, if the court is to be seen as a court of equality, there are many other scenarios right now that the UN Security Council should be able to refer to the court if that court is supposed to look legitimate the way it ought to be, the way we intended it to be as states parties. Thank you.
A further addition to the Kenyan voice. I would kindly...
briefly, we can come back for more questions in a moment. But
Mr. Chairman, a further addition to the Kenyan voice. My honest take is that in the 15 years of Rome Statute, the only lesson we can learn is not a lesson on sitting head of state. And which brings me to my proposition that what we should all of us be so obsessed with is safeguarding the integrity of the court process. That is my submission.
Okay, thank you very much. We'll just go back to the panel and get some reactions to those comments and questions, starting with the first one made by Mr. Keita at the front here. Sarah, perhaps you could respond to Mr. Keita's suggestion. Are we just too optimistic?
I think as a true Frenchman, Mr. Kita asks the existentialist question, what are we all about? And I find one should do a discourse analysis of the rhetoric around the ICC. And what is interesting is that in all the promotional language, the ICC is always promoted and advocated for on the basis of consequentialist arguments. We are here because we contribute to reconciliation. We're here because we contribute to peace. Ocampo made statements, arrest Bashir now and you've got peace tomorrow in Darfur. And this is also the rhetoric of the court itself. I mean, some actors in the court have made a lot of statements like this, including with respect to the victims, of course. It's always everything for the victims, and that's mostly this abstract victimhood. But then, whenever the court is attacked, it is defended on the basis of deontological arguments. We are here purely to do justice and to implement our mandate and nothing else. You can't hold us responsible for what's happening, the impact on peace, because that's the mandate of the Security Council. Now, I'm not saying what is the right approach or what's the wrong approach, but all what I'm saying, pointing to, is this total inconsistency in terms of promotional arguments and defensive arguments. And I think that, so this point that you're absolutely spot on with saying these too big expectations have partially been created by those who are trying to promote the court themselves. So it would be in their interest to be slightly more modest about the possible achievements. Now that brings me to one final point about these victims, because David was absolutely right that this limitation has mostly been happening in the Kenya case, in the jurisprudence. But my point goes far beyond the jurisprudence of the court. My point is about the legalization of victimhood. If you talk with victims generally, for instance in northern Uganda, people who have been born in IDP camps, have lived there for 20 to 25 years, have no future whatsoever because of the circumstances in which they were born. They're not victims recognized by the court because they have not been the victim of a crime that is being prosecuted by the court. So what is happening with victims in the judicial process is you've got a pyramid. The world has a massive base of victims. But what is happening through the legal procedure is that that pyramid is getting narrower, and ultimately you've got in the Lubanga trial 4 people appearing, the victims appeared. Now, that stands in a sharp contrast with this massive base of suffering. And on the other hand, you've got this abstract victimhood, the victims with capital T, capital V, that halos above all of this. And the point I was trying to make is that this legalization of victimhood on the one hand, and the rhetorical reference to the victims on the other hand, is increasing a bigger and bigger and bigger gap. Now there are several ways of addressing that, and David would argue, or at least that's what I implied, like what I understood, the Kenyan jurisprudence is wrong. My point is much more, this is inherent in the judicialization of victimhood, but make sure to be extremely cautious with this reference to the victims deserve justice, or the victims want this, or the victims want that. So much more caution with respect to this notion of abstract victimhood. Sorry for the long response.
Yeah. Thank you, Sarah. And Ambassador Thompson, if I could ask you to respond to the same issue. Is it just a brief point?
Very briefly,
okay,
7,000 victims decided to come and participate in court proceedings. No one obliged them. They decide, it's a right to be participating, to accept the judicial process. It's not that you buy into some sort of propaganda or whatsoever. These are individuals who decide. They are a minority. I agree they are a minority. But if it's meaningful to them, it's meaningful to me. If they are 4, I'm happy of them. If the 4 have some level of satisfaction participating in the process, wonderful. The fact that they are few and they are a minority does not need, and more or less in these situations, also in domestic systems, they always are a minority. Let's not think that the criminal justice process is the way to solve the problems of the entire. I've never said that, and I'm not a policymaker. I'm just one person who believes that when the mayor of Taba, Kayesu, was tried, because I was there, and the communities of the city of Taba came to represent those victimized, the moderate Hutus and the Tutsi, and they were told by the prosecutor at that time, a Kenyan man, Androniko Adede, no, go in the gallery with David and other people because you belong to the general public here, you don't belong to the proceedings. These guys were devastated, and they left Arusha, and they didn't support anymore the court proceedings that they were so eager to attend as victims, as representing their communities. So why not to give this legal chance, which is existing in so many places? It's not up to us to, I mean, we have to be realistic, and I disagree with the Maître Keita approach. We know our place. This is a criminal justice process. The Security Council is failing on Syria, and we denounce it every day. I have, in this room, there are organizations like Amnesty International and others who are denouncing the inaction and immobility of the Council every other day. We are doing it, but you know, because we cannot do something there, it's not a good reason not to do something here, where we have a treaty-based jurisdiction, which, however, as we have learned from our masters like Professor Otto Trifter, it applies on behalf of the entire international community certain principles of law that have been accepted by all. So why not to move with what we have and then incrementally try to bring equality in the next 10, 20, or 30 years, because you know there is a lot of work to be done, and there is and we need a place where to start. So the ICC gives us enough ground to start the job and try to put an end to impunity, which is, yes, is an utopia. There will always be some form of impunity, but that doesn't mean that it's not right to fight for that. So I do believe that we are not here, there are no conflicting opinions here, because my expectations, and I hope the expectation of many, are not that we are changing the world through the criminal justice process.
Okay, thank you very much, David. Yeah, Ambassador Thompson, if I could come to you on this issue of optimism and prioritizing of victims from a state's party point of view. Is that something that we're way off from where they want it to be, or what is your view?
The ICC is an international tribunal. States, sovereign states of their own free will, who subscribe to the object and purpose of the Rome Statute, decide to become parties to the ICC. So states would have accepted it. A contract among states. These are the rules. I agree to abide by the rules. I find it very curious that states would then say that, don't look at me, look at somebody else. Somebody else is doing as much or doing worse. You've agreed to abide by certain rules. These are the standards that should obtain. And if, in fact, you're in breach of those standards, then you should be called to account. By becoming a party to the instrument, you agree that you would subscribe to certain standards, and if you breach those standards, then you ought to be called to account. It clearly is not sufficient to say that other persons are, in fact, also in breach. Some of them also should be called to account. In fact, all of them should be called to account, but as indicated earlier, there are legal constraints. If they're not a party to the statute, then they may not be called to account. But that is no reason to say that you should not be called to account, or that is no reason to deflect attention from whatever offenses may or may not have been committed in your jurisdiction. So I don't find it a sympathetic argument, really, to say that there are other places where things are worse or as bad, and therefore don't look at me, look somewhere else. That really is not, in fact, a compelling or a persuasive argument. The point about whether we are expecting too much, I come back to the point that the institution is a young institution. Right. The first bench of the ICC would have been created in around 2003. So it's not 10 years. It is a creation of states, of sovereign states. Again, the court needs resources to do what, in fact, it has to do, what states parties wanted to do. To the extent that it has those resources, it will be able to do more. If it has insufficient resources, it will not be able to do as much. And of course, victims assistance is one of those areas where, in fact, resources could be more plentiful. And so I think my view is that it is still early days, which is not to say, of course, that one can criticize performance to date. In fact, if criticisms are warranted, in fact, the court, like any other institution, should be criticized. It has to be accountable. It has to be accountable to states parties, and of course, to the world at large. Its goals are lofty, very lofty. Somebody has to do it. If it was not the ICC, we would think that the world in 2013 would have created an institution to address those very points. Certainly, we have moved beyond the point where we will regard these crimes, war crimes, crimes against humanity, genocide. We have moved far beyond the point where we will, in fact, regard these offenses as simple offenses and not to be treated specially, and not to have the greatest opprobrium attached to their commission and to their perpetrators. So I am optimistic. I think we in Trinidad and Tobago we attach particular importance to the institution. We see it as moving global society forward in terms of ending impunity. And to the extent, again, that we are having this debate about whether special procedures should apply to high functionaries, I think to the extent that we are having this debate, I think crystallizes the view that we are moving forward. In another era, in another place, without the Rome Statute, there would have been no issue to discuss. So I think it is more positive than not, and in fact we remain optimistic on the progress of the institution.
Okay, thank you very much. And Njonjo, if I could just ask you to speak briefly to Mr. Kida's question, but then also respond to the comments and questions from the members of the Kenyan delegation, and particularly this issue of victims being misused or mistreated in some way by those that are seeking to prioritize their needs.
I think the earlier question that was asked by my colleague, I think, seems to have received enough airtime from my fellow panelists. So let me, because of time, just focus on 3 quick points in response to what the Kenyan delegation is talking about. I think sometimes I find it disturbing that government delegations come to meetings like this and just bandy about figures and facts that are supposedly true merely because they are asserted. The thing is, when someone says that people like Njonjo Mue do not talk for the victims, it's your right to believe who I work for, who I speak for, but at the very least you can avail yourself of the letter that I referred to earlier that was written by the victims' legal representative, Agol Gaina, to the UN Security Council about 2 weeks ago. It very carefully documents what the experience of victims has been with regard to the reparations and resettlement claims that you are talking about. And then I would also like to refer to you to the report of the UN Special Rapporteur for IDPs, who visited Kenya and wrote his own independent report based on his own investigation, that there were huge gaps, and the fact that the victim so-called compensation scheme was skewed ethnically. Now that is not an NGO, that is the UN itself saying that. So the second point I want to make out of the 3 that I want to make is that, one, it is clear there are many victims in Western Kenya, in Nyanza, Kisii, who have not seen any amount of compensation. When you bandy about a figure of 4 billion, I'm not quite sure where that amount is. It would be good if you could let us know where it is so that we can direct the victims to that fund. The other thing is that there is a tendency in Kenya in this discourse to conflate or to reduce victims to IDPs. There were hundreds of women who were raped, many of them infected with HIV/AIDS. I would like to know about those people telling us that there has been compensation, whether anyone has compensated the 1,133 people who were killed. There are many other victims who are still waiting for the so-called compensation. finally, no, the second point I want to make quickly is that Mr. Corrie refers to the Truth, Justice and Reconciliation Commission and suggests that we boycotted it and preferred to externalize the Kenyan cases. Actually, it bears saying here that the TJRC was slow punctured by the fact that the person appointed to chair it had his own issues. He was alleged to have violated several human rights which the commission was supposed to investigate. And so Kenyan civil society decided that that he could not lead an honest process. And the TJRC process was hampered by the fact that Ambassador Kiplagat remained at the helm to the end. And even when the TJRC completed its report, while it was waiting to get an appointment with the president, the current president, to hand over the report, there were officers from the office of the president calling the commission and demanding that certain aspects of the report be changed. And they managed to get that changed. And then finally, the report was sent to Parliament, and instead of implementing the recommendations of the report, as weak as it was, the Kenyan Parliament decided, led by the Attorney General, decided to draft an amendment to the TJRC statute to give themselves power to amend the bits and pieces that they didn't like. So when you talk about the TJRC as being a comprehensive model of delivering victims to justice, I'm not sure what you're talking about. Finally, because of time, my sister, whose name I didn't get, says that Kenya is not demanding the amendment of Article 27, but an accommodation, what you call very beautifully a procedural accommodation. I wonder though, I mean, it is clear, of course, Kenya doesn't stand a chance of getting Article 27 amended given the rigorous process that is required. But what Kenya is trying to do, given the drafts that we've seen the last 2 days, is to amend Article 27 through the back door. And you are saying that you want a procedural accommodation so as to balance between what Mr. Kenyatta must do attending his trial and governing the country. But it is the same candidate Kenyatta who told us that the ICC was a personal challenge which he would be able to deal with and govern the country when he became elected. I would like to know when this personal challenge became escalated to such a global crisis that every international meeting must come to a standstill so that Kenya can be heard.
Okay, thank you, Njonjo. Time is pressing on. I don't wish to keep any of you from the bar much longer, so I'm going to ask the panelists a final question and to answer very briefly, if you would. We've all highlighted many challenges facing the court here this evening, but I think we can all agree in this room that we want a court that dispenses justice that is fair, that is neutral, that is balanced. So if there's to be whatever the outcome of these cases in Kenya is over the coming months, what would be a successful outcome for the ICC that it can be marked as a leap forward for the court? And I'll start with you, David, if I may.
I really cannot answer this question. I do apologize, but I think the court is applying the law, and that's what it is. So whatever the outcome will be, it will be fine, because the court is applying the law, and it's not about the outcome. It's about, doing what a judiciary. I don't necessarily mean like
in terms of a judgment or anything like that. I mean in terms of all the elements that we've discussed here this evening in terms of how the court operates.
No, I thought you were referring to the two cases.
Because no, I'm not talking about a legal judgment.
That's fine. Yeah. I think that allowed me the opportunity to make the difference between the courtroom, what must happen in the courtroom, and what we can debate outside the courtroom, because we have a profound respect for that. So I do believe that if this debate around sitting heads of states or former heads of states or non-heads of states who campaign and then become heads of states will help us in sending the message or reinforcing a message that is certainly already out there, that you cannot behave in the way in the past certain leaders have behaved. If that is the outcome, then I think it would be an enormous success. And of course, it's consequential, but it's consequential not to other goals, peace or, it's consequential as of what criminal law and the legal system is about, to try to bring a condition through which individuals and groups try to respect each other and respect the law. So if that is the case in the long term, I do believe that that would be the most successful outcome.
Okay, thank you. And Sarah?
Okay, so I think my response follows neatly on this point, because for me, ultimately, criminal law and law, they barely bring justice. Now, of course, they may bring a component of justice, but the key problem, and I think therefore also the key solution to that problem, the key problem is what is happening is that global justice is becoming monopolized by the discourse of international criminal law. And global justice is so much more than just than passing judgment. It's the easiest thing almost you can do. Passing judgment is easy, bringing real justice to this world requires all kinds of other measures. And the problem is more and more that the enforcement of one particular tiny little bit of law, international criminal law, is being monopolized by this movement as being global justice. And for me this, and just to go back to Kenya, today I received an email from somebody in Kenya who wrote, "The trial of the president and vice president is one of the most topical issues in the country, occupying prime TV on TV news networks, front pages of the local dailies, and discussed in all manners of social settings, from the bars to the hair saloons. The discussion of the political and socio-economic issues appear to have largely fallen to the wayside." And I'm very sad that the Kenyan delegation has left at this moment. "A worry of mine is that, because of this preoccupation, the ICC and the trial of the president and vice president will become the main narrative of a moment in history, and as a nation we will have missed the opportunity to address phenomena contributing to systematic injustices and cyclical violence." So my hope is that we focus in all our debates and all our intentions in international law. We have institutionalized only criminal justice. We haven't institutionalized the other elements of justice. I'm not saying that we should institutionalize the rest, but at least the one institution that we have for justice shouldn't become or monopolize the entire debate on global justice.
Thank you, Sarah. And Ambassador Thompson.
Thank you. I think it's positive that we are in fact engaging in this debate. I would answer the question that's the basis of this meeting by saying, really and truly, I don't think it's the beginning of the end. I think it may more accurately be described perhaps as the end of the beginning. I think what you have now really is the court moving forward, and in moving forward, right, there will be challenges. I think this is one example of that challenge, and of course, states parties would deal with it to the extent that, of course, it is the focus of attention. Again, it is natural. I think that it would generate a lot of attention in Kenya and other places as well, because what it symbolizes, and I think what it symbolizes is that the idea that powerful persons, powerful politicians can be immune, clearly that is under serious threat. I think for that reason, the fact that President Kenyatta and the others have submitted to the jurisdiction of the ICC is positive. Clearly, I think certain states, certain leaders in certain states do not believe, I think, that they can in fact follow the path, say, of the Sudanese president and remain, as it were, within the fold, and particularly for a state that is a state party to the statute. So I look at it. I look at it as a positive development. Feeding problems, yes. Challenges, yes. The court needs more resources, yes. Victims need greater attention, yes. But fundamentally, that is a matter for states parties. In the same way that the question of cooperation and the question of enforcement is a question for states parties. That too is a development, is a matter in progress. Greater work needs to be done insofar as that is concerned as well. But fundamentally, it is really the challenge for the states parties, and to the extent that this matter is these trials are before the court at this point in time, to the extent it generates this kind of attention, I think it speaks to, hopefully, the end of impunity, which is what the Rome Statute envisages and hopes for, the object and purpose of the instrument. And I think really it augurs well for the future insofar as that is concerned.
Okay, thank you very much. And finally, Njonjo.
I think it's important to go back, being a Kenyan, to state that Kenya is celebrating its 50th year of independence this year. And those years, while we have much to celebrate, we also have much misgiving about our independence because of the history of impunity that our country has experienced. We have lived in a polity where there were some people who were untouchable regardless of what they did. And people have been talking about how the 2013 election was peaceful. The variable in 2013 election was the ICC, because politicians knew for the first time that they could not practically or literally get away with murder to get to power. So I think that this moment that the ICC is facing at the moment is the quintessential problem that the ICC was created to face. If it weathers the storm, then it's going to be a great leap forward. If, as I said at the beginning, it does not, it makes accommodations that will end up slow puncturing it, then it's going to be the beginning of the end. And just to respond to what Sarah read, the email that Sarah read, I completely agree with you that it's really a pity that the whole country, the ICC cases have sucked up all the air from the room. As far as that goes, I think there are very many important things that are going on, particularly as we continue to implement the new constitution, that need to be part of the conversation, and they're being, in a sense, eclipsed by the ICC. But having said that, I think it's important to know the context in which that is happening. That Kenyan public life has been dominated by a very small political elite. And it is that elite that has sat at the top of a country that is one of the most unequal societies in the world. In fact, just today, a report was launched in Kenya titled The Inequalities in Kenya, Pulling Apart or Pulling Together, by the Society for International Development, that shows the very sorry state of inequality in the country. And this is because resources follow power in most of the African countries. And people then fight to the death to capture power. So if you don't deal with the issue of impunity and accountability, you will not deal with the issue of inequality. And that's why the ICC remains very relevant, and it must stay the course in Kenya.
Okay, thank you very much, Njonjo. And with that, I'd like to call an end to this debate and thank all my panelists very much for some really insightful comments on this issue that, has obviously caused a great deal of thought and provoked a lot of debate over the past week, and we still have a couple of days yet to go. And with that, I'd like to also thank the audience and invite you all to take some refreshments at the bar just outside there. Thank you very much.